Hi, this is Kina Kim with PivotalDiscovery.com, and today we're here with Allison Brecher, who's the Senior Litigation Counsel and eDiscovery Coordinator with Marsh McLennan. Allison, thank you so much for joining us today.
Great, thanks for having me, Kina.
And Allison is going to share some tips for corporate counsel today. Allison?
Sure. Well, in terms of eDiscovery, I've been handling legal holds and implementing them at Marsh McLennan for over 3 years. So having done this many times all over the world, because someone disliked me enough to give me that kind of responsibility, I can tell you that what works for me and my recommendation for other counsel is really to create your own eDiscovery wish list. And by that, what I mean is that I think that when most of my counterparts at other companies have litigation, the natural tendency is to preserve everything. Stop all backup tape recycling, have everybody preserve every single piece of data on their home computers and company computers, wherever they may exist. Sometimes that's the right strategy, but sometimes it isn't. It could lead to a lot of unnecessary costs and burdens, and in my opinion, might not necessarily be the best way to go. Instead, what I suggest is an eDiscovery wish list. And what I mean to convey by this is that it's a short list of your goals to accomplish during electronic discovery. And I approach eDiscovery the same way that I approach any other kind of case management plan, where I defend the substance of the case, and I also defend the electronic discovery aspects of the case. So the first step in all of that, of course, is issuing a legal hold notice. It's appropriate to consider, since you can have more than one legal hold, you might want to think about whether there might be different notices needed for different groups of people. So for example, maybe you have people in other countries where there are data protection laws, or perhaps the instructions in your legal hold notice don't translate as well to some other languages. There's nothing that stops you from having more than one. Likewise, there might be a group of so-called key players, and there might be a group of other relevant employees who perhaps are kind of tangentially related to the project or the projects or the files at issue, but maybe a different legal hold notice with not as many details or different kinds of details is more appropriate for them. The next step in all of this, in my opinion, is doing a comprehensive interview. That interview should really encompass whatever you want to get out of the eDiscovery process. So for example, again, in my experience, I think most employees consider documents to be the paper files, the client files, maybe Excel spreadsheets, maybe some Word documents, things like that. But beyond that, I don't really think that most non-lawyers consider things like voicemail, instant messaging, JPEG, like photograph files, cell phone text messages, unified messages, all the things that we deal with at organizations. I don't think most people consider that to be a quote-unquote document for purposes of a Rule 34 interpretation. And so our employee questionnaire, which I think it's helpful to create it when you're not in the chaos of litigation and can spend some time thinking about it. We of course ask about client files. I think it's also helpful to ask about what kinds of abbreviations or code words, for example, did you use for the projects at issue, because that's going to help you create your keyword list down the road so that you can defend that process. In the employee questionnaire process, if they telecommute or work remotely or travel often, those are the kinds of questions you want to ask, because that's going to lead you to where other data may reside. So if you're dealing with a dozen or so relevant employees and all of them telecommute, you should really ask about home computers, thumb drives, CDs, removable media, all the things that I think typically people tend to overlook because they're kind of beyond the boundaries of the normal, so to speak, document preservation universe of client files and paper files and filing cabinets. You really need to think outside the box because data lives everywhere. You should be asking in that context about public email accounts. Do they have an AOL account where they used to send company-related data and project files and things like that? We've already talked about home computers. You ought to be thinking about, again, client files that are in a home office, whether those files are in paper or electronic form. off-site storage. These are all the kinds of questions that, in my opinion, go into a comprehensive employee interview. And I think unless there's some sort of circumstance otherwise, it's helpful to use that same kind of interview questionnaire for all of your employees. And sort of from that process, that's where you come up with what I would call the wish list. What are the particular sore spots, so to speak, or particular items that you as your organization or you advising the organization would like to not have to preserve? Is it backup tapes? Is it backup tapes in Asia Pacific or another region that might have some kind of stringent data protection laws? So that's really the process that we go through, and I think it's a best practice.
Great. Thank you so much for joining us, Allison.
Oh, my pleasure.
Excellent.